Welcome to Right Now, a new video series where Wright Lindsay Jennings' legal team explores hot topics in the world of banking and finance law. Our goal is to give you a heads up on the legal issues and challenges financial professionals should prioritize right now.
Welcome to Right Now. I'm Jake Fair. This is Adrian Baker. We're here to talk today about the Chevron case at the United States Supreme Court. Chevron's not only a local gas station, it's also an important Supreme Court case. So, Adrian, what is the Chevron deference?
Chevron deference is a principle of law that was established back in 1984 by the United States Supreme Court in a case involving, you guessed it, Chevron. And in that case, the United States Supreme Court said that when federal courts are interpreting regulations, federal laws and regulations, that if there is any ambiguity, they are to defer to the judgment of the regulators who are charged with enforcing it. So in layman's terms, that just means, for example, if you're the EPA, the Environmental Protection Agency, and you're charged with interpreting and enforcing environmental laws, that if there's any uncertainty in what those laws mean, courts are required to defer to the interpretation of the agency.
So specific to banks, what was the impact of the Chevron case for bank institutions specifically?
Sure. Well, Chevron kind of opened the door for federal regulators to increase their power, increase their purview, some would say. And that is because there are a number of areas of the law where the statutes passed by Congress leave open questions. And it opened the door for regulators to sort of fill those gaps with their own interpretations, which then sort of take on the force of law. Recent examples that impact the banking industry involve the CFPB. So the CFPB has issued guidance in the last few years about things they're going to look at during bank examinations, for example, with regard to fair lending laws. And they're really layering on additional requirements that they're saying banks need to fulfill. And those requirements can't be found in federal statutes. So they rely on Chevron deference to give them the legal foundation they need to fill in those gaps with their own interpretation. And of course, if they're challenged under Chevron, courts were required to defer to the CFPB.
Well, I for one am shocked to hear that Congress passes laws that are less than clear. But so is the Chevron deference, is it fair to say that it has resulted in banks and other financial institutions being less willing to challenge questionable interpretations of the law by agencies because of the deference that's given?
Yes, absolutely so, because they know that if the regulator says this is how it is, that in order to overturn that in a court of law, they're going to have to convince the judge that the regulator's interpretation is unreasonable. So it's not enough for the judge to say, I think the bank got it right and the regulator got it wrong. The court has to say, not only did the regulator get it wrong, but they are so wrong that it's unreasonable. That's a high bar.
So the Chevron decision recently from the Supreme Court, what did it do to that previous decision from, I believe, the 1980s?
Sure. So the more recent case that the Supreme Court decided walked back Chevron deference. And as we've seen with other topics recently, the United States Supreme Court is willing to not only upset the apple cart, but just flip over the table. And they did that with Chevron deference here in the more recent case. So what they said is that courts are not required to defer to the interpretations of the regulators who are charged with enforcing regulations. So now it's up to courts in every case to decide what they think it means and what's right.
And I've heard some commentators say that that makes sense because the agencies aren't necessarily in any better position to interpret a statute passed by Congress than, say, a bank or other institution. So I've heard that commentary as well. Does this new decision mean that there's going to be less regulation?
No, I would say no, because regulators are going to regulate. The difference now is that before, banks could look to, for example, one regulator. So, for example, if a bank's primary regulator is the OCC, then the bank could look to the OCC to figure out what the OCC thinks these rules and regulations and statutes mean. And the bank has the knowledge of how it's going to be applied by their regulator. But now the bank not only has to look and see how the OCC interprets regulations, but they're going to have to keep up with how a myriad of courts from across the country have interpreted those very same statutes and regulations. So I would say it's not going to decrease regulation. It's just going to make it harder to know what those regulations mean.
Do you think it will make banks more willing to challenge interpretations by agencies of statutes?
Absolutely, it will. I think that we're going to see a big influx of litigation by banks across the country who are challenging regulator decisions. Of course, as many probably know, the CFPB just survived a challenge before the United States Supreme Court to its funding mechanism, which gave the CFPB new life. And they said, we are going to charge forward, full ahead with our regulatory actions and enforcement actions, but now that's going to face challenges that have new legs from banks about whether the CFPB is exceeding its authority or properly interpreting its regulations.
Will banks still have a voice in regulation?
Banks will still have a voice in regulation, but it will not be as powerful as it has been in the past. Of course, banks have to work hand in hand with their state and federal regulators, and they always have. It's always been sort of a give and take between regulators and regulated entities. That will still be the case, but of course, where banks could exert some friendly influence over their regulators in the past due to shared goodwill and history, they're not going to be able to do that with courts. So yes, they will still have a voice in regulation, but it's not going to be as influential as it once was.
If this means less regulator overreach, which is what I think I hear you saying, is because of the ability for banks to challenge interpretations by federal agencies, will it save banks money with the new Chevron decision?
I would say that's hard to predict. Will it save banks money? Because in some ways I would say potentially yes, because we may get some court decisions that say that, for example, a regulator is overreaching or banks are not required to comply with certain regulations. On the other hand, there's going to be a higher compliance cost for banks across the board because, again, not only now do they have to be aware of how their regulators interpret statutes and regulations, they're going to have to stay abreast of how different courts are interpreting it as well. And that's especially important for banks whose footprint covers multiple jurisdictions.
And is that because there will be more challenges to the regulations?
Yes, more challenges. So in theory, you could wind up with a situation where Bank A and Bank B are competitors. They're across the street from each other, and they both challenge the same regulation, but one of them draws Judge A and one of them draws Judge B, and they get different decisions on the same issue. So they're not on a level playing field for a while. So whoever gets the short end of that stick is going to be at a competitive disadvantage. And then that's going to put them in a situation where they need to appeal. And so we're going to end up with a lot of litigation going up to appeal. And I think we're going to see the highest courts of states and the highest courts, courts of appeal and last resort in the federal system ultimately deciding what a lot of these regulations mean. And it's going to take several years for that to shake out.
Yeah, and in my view, it's not a lot different than what we see today when you have a financial institution that's operating in multiple states that cross Court of Appeals, different circuits, and they get different interpretations of the same, whether it's Regulation Z or whatever it may be, in different circuits. It's one of those compliance issues that banks have to deal with, unfortunately. So what, if anything, should banks do in response to this case from the Supreme Court?
Sure. Well, being aware of the implications is important. And really, I think the best thing banks can do is sort of reframe their thinking about what compliance is going to look like going forward. Because on the one hand, while I think many cheer the potential for reduced regulation, which, banking is one of the most heavily regulated industries in the world, certainly in the United States. So while many cheer the potential for reduced regulation, there is a countervailing cost that comes along with that. So banks need to be prepared to figure out either, attorneys or consultants or other professionals internally or externally to help them stay abreast of what's going to become a much more uncertain regulatory and compliance environment.
As it relates to the Chevron deference in Arkansas, do state agencies in Arkansas, have they been given deference in the rulemaking process as you've just talked about, or is that our Arkansas state agencies different?
That's a good question. So Arkansas has not had its own version of Chevron deference. That is a federal principle, not a state principle. And in Arkansas, state agencies historically are not entitled to deference in their interpretation and application of statutes and their own rules and regulations. In fact, to the contrary, we have some case law in Arkansas saying that agencies are held to strict adherence to their own rules and regulations, and they do not receive any deference at all. So that has always, in the state of Arkansas, been a bit different. And so I think at the federal level, it's probably now going to come closer to what we've experienced in the state of Arkansas.
Well, thank you for talking about Chevron and informing everybody that's not just a gas station. Thank you for watching right now.